seat. Okay, sir, tell me your name for the record.
Lamar Vining.
Okay, ma'am, your name?
Kimberly Malone.
Okay, and now that we've called the case, Ms. Trout, you can put your appearance on.
Ms. Trout, Bernadine Trout, Your Honor, representing Ms. Kimberly Malone, who's here in the courtroom to my right.
All right, so, Mr. Vining, how many witnesses do you think you'll call today?
Possibly 4 to 5, and I have one witness, the school principal. I need to call over the phone. She
Okay,
cannot
so
make it.
before we sort of settle on that, what would your 4 or 5 witnesses help you with? What are they going to testify?
I'll just rebuttal in each point.
Okay,
There's a myriad of points. I think there's about 9 different claims she's made.
okay. And how about you, Ms. Trout? How many witnesses? You said you had 2?
I have 2, Your Honor.
Okay. So if I can sum up kind of where we are, essentially this is, although it may not have initially been, the motion was filed, I think, regarding custody, but what it really was is a change of domicile.
That's correct.
And then the response was to the motion regarding change of domicile. So, so this is not an, so in the event that I don't grant the change of domicile, are we really still addressing the question of change of custody? Or are we really then talking about, if I grant the change of domicile, that would necessitate the custody change best interest analysis, and then we would potentially have to come up with a new parenting schedule?
The latter is the correct.
Is that your
Alright.
understanding too?
I believe so.
So in essence, if I don't grant a change of domicile, I'm not today looking at a change in the schedule of parenting.
No.
Okay. All right. So, so it is Ms. Malone's burden to go forward under the statute regarding change of domicile to convince me. I'm just putting this out there, and of course, Ms. Trout has advised her of this, that if I find that there's an established custodial environment in both homes, then she's got to convince me with clear and convincing evidence that the move would be in the best interest of both the child and her, the children and her. And if I'm not so convinced, then if I deny the change of domicile, I'm not going to proceed then with a review of parenting time today. So as far as witnesses go, if people are here to support you, they can stay in the courtroom. If they're here to testify, then they're going to need to sit in the hallway and wait until after after at least the 2 of you testify. What we will do, though, if we have anybody here who's a non-family member, we'll probably take those witnesses first so that they can go, even though it would be out of order. So in other words, if people are here kind of to testify about you being a good mom or you being a good dad and their family or friends, I'm going to make them suffer and wait. But if people are here kind of, they've been subpoenaed for part of their job or something like that, if they're kind of here to testify and they're not family or friends, then we'll probably let them testify first and then they can leave. Okay?
The principal said she could possibly be reached between 1:30 and 2:30. I wasn't
Okay.
sure of the time and the dynamics.
Well, I mean, so what we'll have the luxury of doing is that if after we have the witnesses and maybe after your testimony, if at that point, if I don't feel there's enough to grant a change of domicile, we won't need to talk to the principal. Do you know what I mean? So if I do, then then we're not going to bother because I'm calling that person anyway. So that we don't have to do that right away.
Okay.
Okay? All right. So who are your witnesses? Let me ask you, sir, are your witnesses kind of friends and family?
Karate instructor, tutor, family friend.
Let me ask you this. Do you have anybody here that's here under subpoena that needs to testify and leave right away?
No.
All right. How about you, Ms. Trout?
I do, Your Honor. Both of my witnesses, Your Honor, Ms. Triplett and Ms. Smith, are subpoenaed, and Ms. Triplett definitely has an appointment this afternoon. So I would request that she go first.
Okay,
And Ms. Smith is a subpoenaed witness also.
okay. So, so your case in chief first anyway, so you could call them first regardless. So what I'm gonna do though is have any potential witnesses go sit in the hall, okay? If you're not gonna testify, you can stay in the courtroom, and after you testify, if you want to, you can stay in the courtroom. All right? Okay. So we received in December Ms. Trout's trial brief, so I've reviewed that again. And Mr. Vining, you filed your response, which essentially is your trial brief, so I've reviewed that as well.
The original, because I did supply it twice.
No, I know. I saw the one you just did in April, so that's what I'm talking about. Okay. All right, Ms. Trout, you want to call your first witness?
Yes, Your Honor. I will be calling Ms. Triplett to the stand. I'm gonna go out and get her.
Is there a way that the court, I got a pen, my pen ran out of ink.
Yeah.
Thank you.
Sure. All right, have a seat there, ma'am. And tell us your name and spell your last name. You can sit.
My first name is Elena, Ellynna. My last name is Triplett, Triplet.
Okay. And I'm going to have you raise your right hand. You can sit. That's all right. We're right here. Do you swear or affirm any testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. So you may have been through this before, and I'll just say this for Mr. Vining's benefit. Ms. Trout will ask you questions called direct examination. Mr. Vining, you'll have an opportunity to ask what are called cross-examination. I think, as I read in your brief, you're a paralegal, so you are familiar with this. But, again, since you don't have a lawyer, I'll remind you that you can ask her questions. It's not really your opportunity to respond to her.
Yeah.
Often unrepresented people want to go right at the person and sort of tell their story. While she's on the stand, you can ask her questions and you'll have an opportunity to.
In rebuttal to each question, or they're going to set questions, and I have a turn to just.
So she's going to ask her questions first, then you're going to ask your questions. If she has any redirect based on what you ask in terms of that, she can do that. I then have discretion as to whether I'm going to allow you to ask any final questions, and then she's excused.
Can I ask one more question?
Yep.
Can I object to the entry of things?
Yes.
Okay, I would like to start
Well,
with.
wait, she hasn't
I-
proposed entry yet, so, I mean,
She
let's.
just handed me something.
Right, so she's handing you stuff. As she asks her questions, she may move for the admission of evidence, and at that time, you'll have an opportunity to object. Okay, Ms. Trout.
Thank you, Your Honor. Ms. Triplett, could you state your name and spell your last name for the record?
Yes, Elena, Triplet, Triplet.
And Ms. Triplett, what is your occupation?
At the time of this case, I was a child protective service specialist,
And what is it now?
prevention specialist.
And at the time of this case, Ms. Triplett, how long had you been a child protective services specialist?
A little bit over a year and a half.
And that job is with the state of Michigan?
Yes.
And Ms. Triplett, are you familiar with the petitioner in this matter, Ms. Malone?
Yes.
How so?
She was the mom on my CPS investigation back in July.
Okay. And can you give the full date, July of what year?
July 24th, 2016.
And Ms. Triplett, did you complete that investigation?
Yes.
And did you author a report as a result of that investigation?
Yes.
Do you recall the contents of that report?
Yes.
Ms. Triplett, I think you have a copy already. Do you have a copy of you have a copy of your report,
Yes.
and it's dated July 24th, 2016?
Yes. That's actually the complaint date, that when we received the complaint.
Okay, all right. And have you had an opportunity to review that report?
Yes.
And would it be a complete and accurate report of your investigation?
Yes.
And there's certain parts of your report that have been redacted, is that correct?
Yes, per policy, we do leave out some things regarding providing copies.
Your Honor, I would move to admit Ms. Triplett's investigative report.
Okay,
And
so
I
Mr.
object.
Vining, you've had an opportunity to look at it?
No, I object. I actually did not receive this in exchange of discovery, and I object to it now. I actually never even received a report from CPS for that situation. I never got any final notice on that. I pursued it vehemently up to the state level as to why I never received closure on that case. I've never seen this prior. That's why I initially knew I was going to make an objection to this. This has not been transferred in discovery, so there was no point that I saw this before today, and I never saw it actually in life before.
Your Honor, whether or not he's seen it or not, this is a report from the CPS investigator, authored in the course of her business, and related to a report of child abuse. So I would ask that it be admitted, whether he's seen it or not.
What's the date of the report? You
Um,
said that was the date of the complaint.
The
but
complaint,
What's the date that the report
we had a
was
couple of
completed?
supervision changes, but the actual closure date, we have a closure date when it actually clears through the system. That's on the last page. It's 8/22/16, and that's once it's been approved by a supervisor. But we had a couple of changes in
So do
supervision.
you have any insight or comment as to if Mr. Vining had requested a copy of that, why he would not have received it?
Yes, I would like to speak on that.
Okay.
Okay, per DHS's policy, you have to submit a written statement with a copy of your physical ID. So you have to actually walk into the office and say, hey, I'm such and such, this is my photo ID, I'm requesting a copy of my report. There's no knowledge of him coming to the office making that report. Ms. Malone, however, did.
Okay. And had he done that, there would have been no objection, there would have been no he could have just received a copy?
Yes, everybody's entitled to receive a copy in their investigation.
Okay. Well, I mean, it goes to the weight of the matter, so I'm gonna admit it if it's authentically authored by you and you're here today. You know, whether or not it has any impact on my decision, I have no idea. I don't know what it says, so.
Your Honor, we are approaching it, and I'm going to be marking this as out of order. It is our Exhibit E.
Okay. Thank you.
Okay, Ms. Triplett, as you've already indicated that the report was completed on August 22nd of 2016. Is that correct?
Yes.
On page 2 of the document, it lists other CPS investigations,
Yes.
and it appears that there were 6 additional reports.
Yes, and that portion, number 2, where it says child welfare, history, and family trends, that is any allegations that are called in or investigations. We do have to list a history of the family. So that's what that portion kind of describes.
And as it says here on this page, there are other reports of child abuse were dated starting in May of 2013. I believe that's May 15, 2013.
Yes.
And then another on August 5th, 2013.
Yes.
And there's no date to the next entry in that log, and so I wouldn't know what date that is, but that would be that log number 3202855. It has no date next to it, but would that be a report also? Would it be counted as a report?
It would be counted as a intake, to be specific. An intake is just anything that is called in, but the actual intake ID, which is the 3202855, was actually rejected.
I see. And other dates for the reports of child abuse were include 9/19/13, 1/27/14, and 2/18/14. Is that correct?
Yes.
And then out of the 6 investigations, it appears that 3 were rejected. What does rejection mean when a report is given to your office?
Okay, well, the Michigan Department of Health and Human Services has a centralized intake unit, which any person or mandated reporter can call in and make allegations against a family, okay? During that time, it's the intake unit's job to evaluate and look at the risk of harm, whether it's to be accepted or rejected. So when they say rejected, that means that they looked at the complaint and indicated that it wasn't classified as child abuse and neglect.
I see.
So let me just jump in here a little bit because, so is it fair to say that after the entire scope of your investigation, that you did not conclude that Ms. Malone was responsible for any abuse or, I mean, I'm looking at your conclusion here. She will not be placed on the central registry. The case will be denied as a Category 4 case with a low risk level. There's no evidence to support allegations of physical abuse against Kimberly Malone. Is that correct?
Yes.
So no services offered, no ongoing oversight by CPS or DHHS, correct? And no part of this investigation was investigating Mr. Vining, correct?
No.
Okay.
That's correct. Okay.
Can- am
Thank
I
you,
allowed
Honor.
to speak?
And
When she's done,
I just
then
want
you'll
to
have an
object. I don't know how you want me to go about,
So
if
what-
I can cut it.
You're gonna
to-
object to my question?
No, to this line of what she's speaking on right now.
Well, okay. Well, what's your objection?
Well, the hearing we're at now is to surround circumstances that happened in a certain time frame. She's walked you back to 2013 and is talking about things that happened previous to our custody agreement in February 2014. This would have no relevancy at this point in time, nor would it be a part of what's going on. She initially did a motion September 12th, 2016, about a situation regarding July 24th, 2016. To be discussing matters that happened previous to our custody arrangement has no bearing on what we're doing. Am I mistaken?
Well, I'm probably at a slightly sort of more summary level. I mean, that's why I started this, but she's asking to move with the kids out of state. Okay? And so I'm guessing, if I were her attorney, that she's trying to demonstrate that you're alleging that there's some question about her fitness as a parent. And so this is being offered for the prospect that there has been no finding by CPS that there's any child abuse or neglect.
Okay, so can I ask a question?
Well, not yet.
Okay,
I'm kind of responding, so I'm going to let Ms. Trout finish, but that was why I kind of cut to the chase as far as.
And Your Honor, that was my next question. Well, second to my next. Ms. Triplett, during your investigation of this report, did you have an opportunity to have a face-to-face conversation with Mr. Vining?
Yes.
And how did you find his demeanor during your conversation?
He did seem concerned regarding the children at the time. After I interviewed the children, they were forensically interviewed, I did have a conversation with Mr. Vining, and he asked me, where do we go from here? And I told him that it's deemed at this time, unless the doctor clarified that it was an intentional burn, that it seems to be an accident, and these kind of things happen.
Okay. Did he become upset at all during that conversation?
Yes, ma'am.
What did he do? Can you describe?
He asked me to leave his home.
And I have no other questions, Your Honor. Oh, just one more. Has there been any other CPS reports, to your knowledge, since this report in
Well, I
August?
wouldn't be able to elaborate on that because I'm no longer CPS, so I wouldn't have that knowledge.
Thank you. Thank you, Ms. Triplett. I have no further questions, Your Honor.
Okay, Mr. Vining, if you'd like to step up to the podium and ask any questions.
All right. You said that you are currently a prevention specialist with the CPS?
Yes.
What qualification, certification, schooling did you have to get to become this?
Well, I have a bachelor's degree in criminal justice from Madonna University.
Okay. Does your degree give you more authority in the realm of abuse than an emergency nurse? Are you more knowledgeable, should I
I'm
say?
going to object to that. That calls for speculation on what an emergency nurse is and lack of foundation.
So I'll sustain the objection. So let me help you out here. This isn't necessary. So she's testified to a report that she prepared that essentially upon her investigation there was no finding of child abuse. Okay. So you can impeach her, but do you have a witness today that's going to somehow substantiate the follow-up theory that there was child abuse in this instance? Because otherwise it becomes irrelevant.
I have documentation of the incident. I have the notes of the incident that were took by the emergency room nurse, the emergency room doctor, and I believe it's an emergency room caseworker.
Okay. Well, if they're admissible, I could look at those, but all I'm telling you is that that's something that I determine. But again, not to sort of summarize your case, but what I'm looking for, and this is Ms. Trout's, as lawyer, Ms. Malone's burden, is to follow through on the change of domicile factors in the statute. And it would be perhaps an easy victory if I were to conclude as a matter of law or fact that Ms. Malone was unfit or neglectful, but I don't know that that's likely to happen, and this report doesn't speak to that. This is just evidence that she was reported to CPS, they didn't find anything. That's it. This really has nothing to do with her asking to move the kids away. Do you follow me?
Yes, I don't know if I'm allowed to try to explain to you where I'm going with the line of questioning and why.
Well, why don't you try to explain that?
Okay. She's using Miss Triplett as a specialist and a professional. She's using Miss Triplett's word and credentials to verify that she was not found, not per se guilty, but at fault in the circumstance. So it's Miss Triplett solely being taken as the authority. The claim here says that he, as in myself, has had CPS investigate her on at least 6 occasions. Well, my line of questioning is going to establish something. First, I've never made a claim to have CPS contact. There's always been a doctor or a medical person.
I'm going to object because he's testifying.
So what you can do is that's what you can ask her then. So in other words, I'm not going to have you impeach her as to whether or not she isn't qualified to determine that there wasn't abuse. You know what I mean? That was her job. She executed this report. You may or may not have agreed to it. If you want to ask her that direct question, is there evidence that she can identify that you are continuously calling CPS? Go ahead and ask that. But that has nothing to do with her professional capabilities. That just is her as an employee of CPS.
So if I just want to make sure that I have clarity. You're indicating that I should not attempt to establish her lack of authority to make the choice?
To make what choice?
The decision. I believe she's saying that she made the decision to not follow through. I think she said that she
just said she authored this report and that she was the investigator, and it's admitted as evidence, and I've read her conclusion, and she signed it. It's not signed underneath by the supervisor, but again, I'm just assuming that's this copy, because had there been a signature at the end of August by a supervisor, there would be services in place and there would be findings that Ms. Malone was neglectful. So the fact that that doesn't seem to be the case, I'm taking this as her conclusion and her report, and that's it. So again, it's not. It is what it is. I mean, and she's not trying to admit it. Neither Ms. Trout nor Ms. Triplett are trying to make it anything more than that. So I'm just trying to tell you, I've reviewed it. It looks like there's no evidence of child abuse or neglect, and that's it. If you want to ask her a question as to whether you've been the one, complaining about this, you can do that, but we don't need to impeach her as not expert enough to render this decision.
All right.
I'm saying that's not relevant to my decision making.
Gotcha.
That's it.
Understood.
Okay.
All right. Move to my next line of questions. Is there any evidence that states that I filed 1, 2, 3, 4, 5, or 6 CPS reports?
Okay, I'm not allowed to confirm nor deny the source of any complaint.
How would it be established that someone is, because the claim is that I did so? How would someone go about establishing that that's done?
How are complaints normally made?
Over the phone through our centralized intake.
Okay. And those can be made by either parents or concerned other individuals or doctors or treating therapists, or it could be anybody.
Anyone from the general public as well.
So there's no way that you can testify that in fact Mr. Vining made those prior 6 complaints.
Correct.
Okay. So then there's no evidence whether you did or didn't, unless it comes through from Ms. Malone or you or somebody else. I mean, but this witness can't support that. So I can't conclude that you did or you didn't.
Is there any way to conclude that? Any possible way to conclude that? I'm asking Ms.
Your Honor,
Triplett.
ask and answer.
Well, I mean, let's keep this moving. So is there any way that you could confirm that?
No, not per policy. I wouldn't be able to.
Okay.
Is there
So
any?
she can't, I mean, I can tell you the only way then would be somebody testifying that I made a complaint to CPS.
Okay.
So,
Okay. When you came to my home, can you identify who all was inside the home?
Yes, you were home, Lamar Jr. and Mayana, if I'm pronouncing it right, was home as well, and a tutorer arrived at the house during the time that I was in the home, and she was located in the kitchen area working with the kids.
Excuse me, I didn't ask the rest of what she is doing. I only asked was anyone else in the home, not the description.
you can't ask a question and then complain that, I mean,
I'm just
she's-
asking yes, no. I just want to establish things in
Well,
yes,
then
no.
let's
ma'am.
get it going here. So, she told you who was there. Okay,
Okay.
next question.
How long approximately were you in the home?
I wouldn't be able to testify the exact time frame.
Ballpark. Half hour, hour, 2 hours, 3 hours, 15 minutes.
I would for sure say at least a half an hour.
Probably not more than an hour.
Yes.
Okay.
Where all did you go in the home?
All right, so I'm gonna interrupt. Again, what's the relevance of,
There's later claims in the motion supplied by the other side that the children do not reside in my home, that they don't live in the home. Ms. Triplett has been in the home. Everyone's been in the home. I'm going to ask them about the home per se, the rooms.
did it appear that there was a residence set up where children could live?
Yes, they each had their own room, and that's where I interviewed them at, in their rooms.
Okay. So that's the extent that she could contribute to that, so that's good. Okay.
Okay. And you just said that you interviewed the children in their rooms
Yes,
separately or together?
separately.
Separately. Do you remember which child went first?
Mayana went first.
Had you started this before the tutor got there?
I wouldn't be able to be accurately with regards to what time the tutor came between the time I interviewed her or not. I can't testify because I don't recall it exactly.
So you don't know if she was there when you started? Is that the?
Yes, I cannot recall if she was there at that time.
Okay. Did you speak to the tutor?
No.
Is there a reason you did not speak to the tutor?
I'm not required to speak with the tutor. I'm just required to talk to the immediate family. The tutor is not technically involved in an investigation.
Okay. Were the children involved with the tutor while you were there?
Yes, they worked with the tutor in the kitchen while I interviewed one another. So when I went to go interview Mayana, Lamar Jr. was working with the tutor. And once I got done with her, she went back and worked with the tutor.
Okay.
So I never had initial contact with this tutor, but I did see her. And you reported that that was their tutor.
Okay. Initially, Ms. Triplett just said she was not sure of when the tutor was there and she couldn't.
I don't care about the tutor. We can move on. That is not relevant at all to my analysis. I mean, candidly, let me just sort of sum up that Ms. Malone has the burden to show me why this move is better for the kids and her. That's her burden here.
Yes.
Your burden is essentially to say that why it would be better for the kids if they didn't go. So I don't know. I mean, I kind of think this witness is done. I can't imagine another question you could ask her that would have any relevance to my analysis in this.
You said there's nothing else I can ask? We conclude.
Okay, next you.
All right, thank you.
Okay, next witness.
Thank you, Ms. Your Honor, I would like to call Ms. Malone to the stand.
Do you have another outside witness, though?
I do. She didn't have an appointment, so
She's not here yet.
she's here.
Well, let's take her.
Okay.
I mean, that way, I mean, again, and Ms. Triplett, if you want to go, you can. If you want to stay, you can. It doesn't matter to me, but I just wanted to give you the opportunity.
I do have prior
That's
appointments, so
fine.
thank you.
So let's take the other witness, too, just so that she has the option to go if she wishes.
Okay, Your Honor, then that would be Ms. Smith.
Okay. And then we'll hear testimony from Ms. Malone, and then I think the next logical witness would be Mr. Vining. Come on up here, ma'am. You can either go around the back or up the front. All right, have a seat. When you're comfortable, would you state your name and spell your last name, please?
My name is Denise Smith, Smith.
All right, now have you raise your right hand. Do you swear or affirm any testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes,
Okay. Ms. Trout?
Ms. Smith, what is your occupation?
I'm a counselor.
And what kind of educational background do you have?
I have a master's degree in counseling.
And what type of counseling do you conduct?
Mainly domestic violence.
Do you have, how do you get your clients?
I'm sorry.
Or do you call them clients or patients? What do you?
I guess you could say clients.
Okay. And how do you get your clients typically?
Usually they're referred to me,
Okay.
and that's usually how I get them, through referrals.
Okay. And who would be your referral sources?
Word of mouth, my website, well, my former website, because it's not really operating right now, but my former website.
Okay. And are you familiar with Miss Malone?
Yes, I am.
How so?
She was a client.
Okay. And so you did counsel her?
Yes, I did.
And
Let me ask a question before we move off or onto specifics here. So are you currently employed by a network service, hospital, clinic, or are you in private practice?
I
on your
was
own?
in private practice. I was
Okay.
private.
So your referrals, when you say you referred word of mouth, you had your own clinical practice that?
Yes,
Okay,
yes.
all right, thank you.
okay. And she was a client. And why did she come to you?
Because she was a victim of domestic violence.
Okay. And did you have sessions with her?
Yes.
And how many? Let's stop. Let me get some foundation. When did she first come to you? Date.
She came to me in July of 2011.
Okay.
As a matter of fact, it was the day before the holiday, July 3rd.
Okay. Okay. And you did have sessions with her?
Absolutely.
Approximately how many sessions did you have with her?
Weekly for about 2.5 years.
Okay.
So 52 times 2 is 104 times 6 more months, 26 more weeks. So
Okay.
So,
All right.
yeah,
So you
2.5
had weekly
years.
sessions with her for 2.5 years.
Yes.
And can you tell me what? How was her mental state when she came to you?
Miss Malone's mental state was, at that particular time, she could not, seemed to be in what is known as the learned helplessness stage. She could not make her own decisions. She was totally just really flighty. I mean, as far as traumatized, it was like a trauma type thing. She was very traumatized. And at that juncture, she could not make sound decisions for herself.
Was she at that time? Was she with her husband at that point,
No,
Mr. Vining?
no, she had left them. She left him with the clothes on her back. So when I met with her, she had just left that situation, and only thing she had was the clothes on her back, and the kids were not with her either.
Okay. And did you discuss the situation that made her leave?
Yes,
With her.
she showed me the picture of her with the black eye and face swollen, and that she had been, knocked down and whatnot. Yes.
Okay. And did you discuss the children with
Yes.
her?
When she left, he would not allow her to take the kids with her. And so she was really, she wanted her kids, but he would not, at that time, he would not let her take the kids with her.
Okay. Over the course of the 2.5 years, did you see any differences in her mental state over the course of the
Over the course of years, she talked about even going back to the relationship because she wanted her kids back so badly that she even talked about going back so that she just wanted to be with her kids. That was the main thing. So over the course of years, we looked at, would it be in your best interest to go back, because her safety was just always being compromised. There were incidents of him trailing her, stalking.
Excuse me, Your Honor, can I object?
You can, but you
I
have
would
to
like,
say objection.
I like to object. I just didn't want to be rude the
That's
last time I
okay.
tried to
Just say
speak.
objection.
I
We don't
object.
call that rude.
I would like to start with the fact, again, we are supposed to be discussing issues that have happened post our custody agreement in February 2014. She's interjecting conjecture. She has not seen me follow anyone yet. She's saying on the stand right now who I followed somewhere.
Your Honor, this is an admission of a party.
Well, so I'm going to overrule your objection, and I'll tell you why. Domestic violence is specifically one of the factors regarding the change of domicile factors, so she certainly can introduce evidence of this sort. Additionally, at least as I would imagine, her former therapist can only comment as to what Ms. Malone told her, so this would be essentially her confirming Ms. Malone's statements. And so I weigh this, not that she's not telling the truth, but I just weigh the weight. I evaluate the weight of the testimony, and I don't know if there's other corroborating evidence or not. So
So this wouldn't be considered hearsay?
it's not,
All
because
right.
if it's statements of either of the two of you through this, then that would be admissible.
Did she ever mention during the course of her therapy with you her seeing her children?
Yeah, that was very interesting in light of the fact that many times when she would go to get the kids, Mr. Viney, would
Yes.
not show up. And she would be distraught about that because she would, take time off of work. She missed a lot of days at work, or either would go to work very late, so she can get the kids, and then he would not show up with the kids. So she was very distraught about that a lot.
And During the course of that 2.5 years, were you concerned about her safety?
Absolutely. There were many times when, as I stated before, about her being followed and different things that I saw that that she showed me a film of him talking, saying things about her, putting her personal, her name and stuff on Twitter or something. I don't really know Twitter, but Twitter, it was something, and he was on there talking about her and saying different things about her, telling her and putting things about her daughter, her older daughter. She has an older daughter. Putting things out there about her, and just things that would possibly compromise Miss Malone's safety. I had concerns about her safety because she would every week for maybe 2, 3, 4 months, she would come with a different situation that she was concerned about as it related to Mr. Vining, how he was doing stuff and
Okay.
saying stuff
When you-
about her on social media.
And is it fair to say that you really represented her during the pendency of the divorce, and you represented her, you saw her, and you stopped seeing her as a patient right around the time the judgment of divorce entered? Do you know that?
Well, to my knowledge, they were never married.
Is this a custody case or?
Because we were never married.
Okay,
You were never
so-
married.
all
I'm
right, so
sorry.
I'm just
I
saying-
referred to him
You
as
did, so
husband.
I
I'm
was
sorry.
like, oh. So this would be the pendency of the case then?
Yes.
Okay, so I'll just, looking through the case, it looks like the case was opened on July 18th of 2011. I think you testified that you first saw her on July 3rd of 2011.
Yes, that's when
And
I
then a
first saw
final
her.
order, final judgment was entered on February 27th of 2014, so that would be July of 11 to July of 12, July of 13. Fast forward another 6 months, you really would have stopped seeing her as a patient right around the time the case concluded. And it
Yeah,
hasn't concluded
we have, after a 2-year break, so to speak, I did I try to do follow-up to see how things are going. And I did a follow-up visit with her, this is May, in December and November of last year.
Okay. I'm just trying to kind of orient myself in the timeline here, so.
Yes,
Okay.
sir. So pretty much, it was pretty much based on,
Pending the case.
yeah.
Okay. Sorry, Ms. Trout, go ahead.
Okay. All right. And then when you said stuff, what kind of things? When you said you were concerned for her safety, and you used the word stuff. And if you could elaborate on what you heard her tell you was going on when you
Well-
said those weekly incidences.
That's one of my pet words, stuff. But actually, okay, wait a minute. Before I answer the question, I want to make sure that we're on the same page. What was the question that you
Okay.
asked me?
Okay. The question was, were you concerned with her safety? And you said, you named a few things, and then you said, and stuff. And I just
Well,
wanted
yeah, that was just stuff. I mean, it was like him following her, him not showing up with the kids, but mainly I was very concerned for her safety based on the things that she was sharing with me in therapy about him putting her stuff out there on social media, her license plate and following her. Those kind of things it was cause for concern for me. So I was very, very concerned about that.
Okay. All right, thank you. I have no further questions, Your Honor.
Okay, Mr. Vining?
I'll just start. Can I ask your name again, ma'am, so I can have it properly?
Denise Smith,
Denise Smith. Can you spell that for me, Ms. Smith?
Smith.
No, your first name. Is it Denice or Denise? Denise Smith. You said you are a counselor or a psychiatrist?
counselor.
Counselor. You said you have your degree from where, ma'am? Did you hear what I
Yeah,
said?
did.
You have your degree from where?
What, is that a question that I need
Yes.
to answer?
Where's your
Yeah.
degree?
You talking about like what school?
Yes. Where did you get your certification or degree for your education?
Oh, Ashland University.
Okay. How long have you been a counselor, ma'am?
For 14 years.
In the time that you've been a counselor, ma'am, have you ever counseled men?
No.
No, you've never counseled men. Can I ask if you're, is it company policy to only counsel women? Do you never have men who have any trouble, or you just don't take on men?
I don't take men because would you like to hear the reason?
I'm just
why?
asking you direct one answer type
Okay,
questions.
I'm
You don't,
just asking if
don't
you
take
needed
men?
to know
No.
why.
don't take men.
Well, I'll bite. Why?
The reason why is because sometimes men tend to form those attachments, physical attachments towards the counselor because they kind of look at them as a savior, and they tend to form those kind of emotional bonds and want to take it further, the counselor-client relationship.
So that's just been your
So
choice
that's
to
my
limit your.
safe,
Okay.
that's my safety mode to keep those professional boundaries in line.
So I got just two follow-up questions. You did say you never had any men, correct?
As
Never.
clients.
Okay, never any men
Not
clients.
as clients.
Okay, the statement you just made to the judge, is that a personal statement that you garner, or is that some type of professional analysis that I could find in some type of doctor review or psychological review?
I believe that you probably, if you did a little
Probably, but you're not
research,
sure.
I
I don't want to speculate, I just want to be
I
sure.
want to let
Okay.
the witness answer the
You know,
question.
okay. I mean, again, she stated that she's limited her practice, so, I mean, she can do that.
Yes, by all means, she can. I would like to drive home a fact with this point.
Okay,
with this.
and
So ask her a question and then.
I did. I asked her, it's a yes or no. Is this information that is either based on your personal reference, or is it something professionally?
okay, what information?
You said that men have attachments to the psychiatrist or the counselor. You indicated that men have some type of emotional attachment, and you called it, I think you said savior, or that was
Well,
the statement?
that is true,
Okay,
and it's
that's
also
true.
true for women towards men.
Okay, so, okay. All right. You gave a testimony, I believe, where you were recanting what Miss Malone said to you in your counseling sessions.
What did I recant?
You said things about things that she was giving a recollection. She was going over things.
Basically giving her, I mean, so, right, so certainly her testimony was formed on things that Ms. Malone told her, yes. So what's your question?
I wanted to ask how she verified the things, if it was just verifiable because Ms. Malone said so, or was there ever anything that gave proof to what she said?
Well, as far as the Twitter thing, I saw,
So this, okay.
and I don't, as it relates to what she told me, I mean, I know that she didn't have possession of her kids.
Okay. I think
and
I
I
have
know
a
that
series of
she
yes/no
did
questions I
keep
just want to
records.
ask. Just a series of yes/no questions. You did say she came to you July 3rd, correct?
Yes,
2011. You said she brought you a picture of her eye that day, correct? You've already said it. Is that
Yeah.
correct? Okay. Are you aware of the date that Miss Malone accused me of the domestic violence? Are you aware of what date that was?
no,
It was July 3rd,
Okay.
2011.
She said no.
Yeah, I'm saying it for the court.
No, but
There was a
this
picture.
isn't your I mean, you'll get an opportunity
Okay,
to
that's
tell
fine,
me.
that's fine.
But
So,
while she's on the
okay.
stand, you said
fine.
series of yes or no
she
questions.
showed me a picture. The picture was on her phone.
That's fine. Okay. She showed you a picture. Good. She showed you a picture on the phone July 11th. Do you know what time you all met?
Oh my God, that was like
So
6 years ago.
If
Do you
no,
do
that's
case
okay.
intake?
But no,
No, you don't know
not
the
right
time?
off the top of my
Okay.
head.
Do you do case intake when you originally see someone?
Do I do case intake?
Yes.
I fill out I have them to fill out the information. Yes.
So, do you keep records of your clients
Up until a certain point.
up until a
Until I'm
certain
done.
point? Okay, so do you have records of that?
I did.
You did, but you don't.
Not now, I don't.
So we have no way to clarify with any documentation what your case intake curtailed of? Yes or no?
Can you specify
We,
what you mean?
if you don't have the documentation, what I'm trying to ask you is that, do you have any way to give documentation to the court, to myself, of what took place in your case intake July 3rd, 2011?
Oh, I can tell you pretty much that.
Documentation, do you have
No.
paperwork? Okay, you have no paperwork or documentation for such, all right. You spoke of Twitter, and you claimed that you saw something. Where did you see this Twitter, something that you saw? Because you called it stuff, and I don't really have the proper garnish.
Did you see it anywhere outside of her showing it to you on her phone? Because you did testify to that.
No.
Okay.
Okay. When she showed you this on the phone, do you know where you were at? Were you in her office? Your office, ma'am?
Yes.
You were in your office. Did you ever get a copy of this?
I had no need for it.
You had no need for the copy, so you don't need to verify. Okay. You spoke about domestic violence. When you got this intake, did you have something to verify that domestic violence took place? Any documentation from court or the legal system?
No, at that time,
Was it a yes or a no?
I'm trying to think. It's been, like I said, it's been 6 years ago. I don't remember, honestly. I wouldn't say yes or no, but I would say I don't remember.
So you don't remember if you had any documentation that domestic violence actually took place?
That's what she just said.
Okay, just want to make sure. She said I don't know. She's not
I
committing to
don't
an answer.
remember.
You don't remember.
I'm not gonna say I don't know. I don't remember.
You can't remember, but you do know.
Okay, we can move on. I got her testimony. She does not remember. It was 6 years ago. Your question was, did she have evidence? Did she have any documentation from a court? Let me ask you, did she bring in any medical records, any hospital records, any police reports or anything? Or did she just, in the context of your therapist-client relationship, did she just tell you about it? Or you may not remember.
I don't remember.
Okay.
Okay. Ms. Smith does not remember if she has documentation, but she's given a testimony of things in a finite, specific way. She said what she knows to have happened.
She testified. I mean, just so that I know that this is where the difficulty of not having a lawyer is, and you've had plenty of experience having lawyers. The difficulty, sir, is that she's testifying as a therapist with the waiver and release of her client or patient. She's just testifying as to what she remembers of the sum and substance of the therapy. So, again, I mean, I give the appropriate weight to her testimony. It's not.
Yes.
But she's clearly said she doesn't remember whether she saw medical or court or police records.
Well, am I allowed to speak now?
It's not. If you have a question for her, yes.
Yes,
If
I
you
have
want to
a-
rebut what she says, you're going to have another opportunity to do it. But it's not while she's on the stand right now. This is not a dialogue between the two of you. Just ask her questions. And if you don't have any,
Well,
it's
I
okay.
have them. I'm trying to adjust them since
Okay.
the questions keep being
Okay.
impeded. I have a long thing of tying it together, so as you say that, I'm adjusting. I'm just taking a second
Okay.
to adjust so the next follow-up question doesn't reach the same outcome.
Okay.
14 years. You said that your services concluded when the custody agreement happened in February of 2014. Did you attend the final hearing or any other hearings?
I did, but I was not called.
Not called. Do you know why you were not called as a witness in a 3-year proceeding that you were a counselor?
Well, I was called, but I was called to witness, and I did come to court on 2 different occasions. But because the other situations with you took so long, with your people, I was never called. I was at court all day on 2 different occasions.
What were these dates? You recall what
No,
happened?
I don't recall the dates, but I was there. I saw you speaking with your mother in the hallway. I was there. So whether it, the dates are insignificant to me.
Okay.
And that was during the time when I met Miss Malone's mother also.
Well, you don't ever remember dates, but you remember the details, okay? So,
Yeah,
we
well, I
don't-
had no real reason to remember the dates.
Did you attend in your time of counseling, Ms. Malone, any domestic trials or hearings?
Meaning, can you
Domestic violence trials or hearings?
I don't know if that was what that was, but I know I came to court on two different occasions.
So you weren't aware of what you were at court for, or what type of hearing it was?
It's been some years ago, so
And you also didn't have this available in your case notes?
no. That had it wasn't relevant to me as it relates to that.
So, the type of hearings are not relevant. Is that what you just said? The type.
I mean, as far no, I
Your
was
Honor,
asked to
I'm
come
going
to
to
court.
object to this line of questioning,
Yes,
and I'm
yeah,
going to ask for relevancy.
I can.
I'm based on relevancy.
Oh yeah, it's very relevant. We have people who are being called specialists. They're giving testimony as to dates and times. When you ask specifics about dates and times, it becomes all vague. You know very specific details about what happened, who was there, but you do not know what type of hearing it was. You do not know where the hearing was going on. You're a professional, yet you have no case notes, no intake notes, or anything. The witnesses I bring in later will clearly show that Miss Denise Smith is perjuring herself. So I need to have these lines of questions here to sit on the record as we finalize and we tie it together. The fact of the matter is she's already perjured herself 3 times. I'm going to show that here today with my witnesses. I also have documentation that we can all crisscross with Central Registry and check. We can check it with the records in Romulus. So if I'm not allowed to ask these questions to lock Ms. Smith into positions in claims, vague claims or specific claims, we cannot show that Ms. Smith is perjuring herself today.
Okay, well,
Well, maybe I can help the court, Your Honor, just to clarify, we're only presenting Mrs. Smith's testimony to the issue of domestic violence, which is one of our factors, and the fact that she had therapy. That's pretty much it in a nutshell.
And if I can rebut quickly, domestic violence is a specific claim. It is a crime which someone is found guilty or not guilty of. So the finite claim here is that domestic violence took place. I counter that no domestic violence took place. My next question, matter of fact, my last question was, did you attend a domestic violence hearing? She stated she was Ms. Malone's counselor for 2.5 years. She stated that many things happened that concerned her. So I would assume that since she can be here to testify today, and she's also said she came to testify, that she would know what she came to testify for and when. If she came to a domestic trial to testify, Ms. Malone testified that day, an officer testified that day, other people testified. Why didn't she testify? I can't
Ms.
impede.
Malone didn't
She's interrupting
I'm
me.
sorry.
I cannot impede a witness from
see,
testifying.
So she testified that she didn't remember what the nature of the hearings were. So why do you think that I wouldn't be able to sort of evaluate her testimony for its importance to me? I mean, you're sort of implying that somehow her non-remembering tells me that she spent 2 days at your criminal domestic violence trial.
No.
I don't have any idea what she attended.
No, I don't either, but she's making finite statements of what she knows. She said, I know. She didn't say, I believe. She didn't say, I think. She said, I know. If you know something, it should be able to stand up to test. We should be able to ask questions to establish the truth of this. So she's made the
She
claim
knows
that
what?
she said she knows that domestic violence took place. She said she knows that I followed Miss Malone and harassed her. She says she knows that I didn't show up with children. She says she knows that I kept children away from Miss
How
Malone.
would she know that?
I wanted to know also. That's why I'm asking.
So if I were to evaluate her testimony, she also answered candidly to you that she didn't do any outside investigation. So I can conclude from her testimony that, like most therapists, she gathered her entire base of knowledge solely through Ms. Malone's counseling with her.
Okay.
She showed her a phone screenshot of a Twitter feed or something that had your license plate or your car in it. But everything, I mean, so her testimony is consistent with that which any therapist can testify as far as their therapeutic relationship. She's not being proffered as an expert witness on domestic violence. She's not being proffered as, knowing that Ms. Malone's symptoms, even if she hadn't treated her, are consistent with an actual victim of domestic violence. She's just testified essentially to what Ms. Malone told her.
She actually stated Miss Malone was suffering from some syndrome. She called it inability to make her own decisions. So she gave it some type of title.
Do you look around? Do you see a jury in this room? No. I'm the one who makes this decision. So I'm hearing her testimony. I'm hearing Ms. Malone's lawyer's questions, and I'm hearing your testimony, sir. I'm telling you, so I'm sustaining the objection as to relevance. So if you have other questions, you're welcome to move on. But I'm telling you, this is kind of where it's going. I don't think perjury is going to come into this. I think that you can perhaps point out through some of your witnesses maybe inconsistencies, but she's pretty much testified to what she knows from Ms. Malone. And that's kind of it. So that's why I was earlier stopping you, because it's not hearsay, because it isn't. I'm not concluding that it is absolutely true that you were following Ms. Malone. All I'm taking from her testimony is that she treated with a therapist for domestic violence, and she asserted, believed, and felt that she was a victim of domestic violence.
And okay, we'll leave it there. So just to move forward, I would like to make sure that I can do the same. So we're not limited now to only events that happened after 2014. We're not limited to direct testimonies. We're actually available to give summaries by other people of what they have heard.
If you have a witness on the stand testifying,
Yes.
that is
Yes.
testifying to their knowledge of what happened, then that you're not limited. That's exactly what Ms. Smith has testified to.
Okay. And
But again, it would be hearsay if Ms. Smith was counseling Ms. Malone's sister, whose sister told her that Ms. Malone was a victim of domestic violence. So in fact, because this is a treating therapist of Ms. Malone, you could offer your own therapist or somebody that you've told things to. So yeah. Let me give you the other law school 101. The classic example would be to call a police officer to testify about their police report. The police report is hearsay. If you subpoena the officer to come in and talk about, I interviewed Kim Malone, I interviewed, Mr. Vining, I interviewed so-and-so, they'll just recount their summary of those interviews. That's all that is, and that's kind of what this is that she's summarizing her understanding and recollection. The fact that she doesn't have notes with her right now is not conclusive of anything to me. You didn't subpoena them. If you did, but she's also asserted that this was a relationship from 5 years ago, and maybe she has a policy of destroying her notes. But no one's offered her notes to me, and so I don't find her faulty or lacking because she doesn't have them with her. That's it. You are free to present in your testimony rebuttal to what she's saying, i.e., she came in here with no notes, blah, blah, blah. That's your testimony. That's not her testimony. Do you understand the difference?
Yes, I'm just establishing for the record the fact that she's made a number of statements, yet there's no documentation here to substantiate any
And I
statement.
got you. I read you loud and clear. That's why I'm saying there's no jury. I'm the one who evaluates this.
I'm just making it for the record.
Okay. Any other questions?
Everything.
You're all set. You can leave or you can stay or go as you wish. I don't want to make you stay all day though.
Thank you, Ms. Smith.
All right. So, I think next you're going to call Ms. Malone.
I am, Your Honor.
All right. And then once she's done, I think we'll have your testimony, sir, and then we'll see about your other witnesses. Okay.
Thank you, Your Honor.
So, it is noon. Do you all want to take a 45 minutes for lunch now, or how long do you think Ms. Malone's testimony will be?
Your Honor, rather than breaking her testimony, I would prefer to take a break.
All right. So why don't we come back at 12:45?
Thank you, Your Honor.
Okay. You can leave anything you want in the courtroom, notes if you want, books or whatever, because we'll lock it when you leave. So no, we'll open it for everybody to come back in when we're here. Okay. I'll see you back here in 45 minutes.
Thank you, Your Honor.
All right.
May I ask a question, please? When